This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice. Welcome to the Luxembourg Fundcast.
Hello, and welcome to the Deep Dive. Today, we're turning our focus to a really interesting area of venture capital. It's something especially relevant for you, our listeners, working right here in Luxembourg's law and finance world.
That's right.
You sent us a great deal of source material, articles, notes, research, all digging into a key financing tool used a lot over in the UK startup scene, the Convertible Loan Agreement. You'll often hear it called a CLA.
Exactly. And it's an instrument that pops up frequently, especially in those cross-border deals between Luxembourg and the UK.
Right. So whether you're, advising a Luxembourg fund that's looking to invest in a UK tech company.
Or maybe you're on the other side, helping a UK startup that wants to raise capital from investors based here in Luxembourg.
Yeah, in either case, getting your head around the UK CLA, well, it's not just useful, it's pretty much essential.
So our mission for this deep dive, and we're basing this entirely on the sources you've shared with us, is to really unpack this thing layer by layer.
Okay.
We'll kick off with the basics. What exactly is a UK CLA? Why do companies and investors use it? Who uses it? And, when does it make sense?
Well, fundamentals. Good place to start.
Then we'll put it in context, compare it a bit to other similar funding tools you might come across. After that, we navigate the really crucial UK legal side, the regulations, the tax landscape that governs these CLAs.
Which can be quite different from what we're used to here.
Definitely. We'll break down the key documents needed and then really get into the nitty-gritty of the important terms you'll actually find inside a CLA agreement.
The clause-by-clause stuff.
Exactly. We'll touch on the common negotiation points where the arguments usually happen. Look at the typical costs involved and the kind of timeline you can expect.
And then bring it all back to Luxembourg.
Absolutely. We'll wrap up by comparing the UK CLA to financing instruments that you might be more familiar with seeing here in Luxembourg. It's the full picture.
Sounds good. It's a fascinating instrument because it really is a hybrid. Legally, it starts life as debt, but commercially, everyone's really thinking about it turning into equity.
That duality seems key.
It is. And understanding that, especially within the specific UK legal and market context, is vital. So, let's start with the definition. What is it?
Okay, let's unpack that. So, at its heart, what is a UK convertible loan agreement in this VC world? Well, the sources you shared define it as a contractual debt instrument. Basically, it's a loan.
Right. Simple loan to start.
And here's the crucial convertible part. The money loaned, the principal, plus any interest that builds up. Well, the main idea isn't usually for the company to pay it back in cash.
No, that's typically plan B or C.
Exactly. It's designed to convert into shares, into equity ownership in the company. But only if certain specific, pre-agreed things happen in the future.
And that conversion into shares, that's the real driver for the VC investors, the most common trigger for that conversion. It's when the startup manages to raise another, usually bigger, round of funding from new investors.
Like a Series A round.
Precisely. Often called a qualified financing round, or QFR. The idea is get money into the company quickly now using this simpler debt format, and then figure out the final share price and terms based on the valuation agreed in that bigger later round.
And the sources really hammer home that this makes CLA super common for early-stage UK startups needing that first chunk of serious capital.
Oh, absolutely prevalent. If you're advising on early UK deals, you will see these.
So who are the typical users, and at what point in a company's life?
You're mainly looking at very early stage companies. Pre-seed, seed funding rounds, that's the sweet spot. The investors putting money in are usually angel investors, maybe some early stage VC funds.
Okay.
And the timing. It often acts as a bridge. It bridges the gap, funding-wise, between maybe the founder's initial money or very early friends and family cash and that more formal, properly priced equity round later on.
So it gets them over a hump.
Exactly. It provides that necessary capital injection without forcing everyone into complex valuation discussions or heavy legal docs too early, when the company might just be an idea and a small team.
Which leads perfectly into the why. Why not just do an equity round from day one? The sources point to two main reasons, and they seem tightly linked. Speed, and crucially, pushing the valuation decision down the road.
Yeah, those are the big ones. Think about a brand new startup. Maybe they have a great idea, a smart team, but almost no revenue, maybe limited proof the market wants their product.
Just a prototype, perhaps?
Right. Trying to agree on a precise, justifiable valuation for that company. It's incredibly hard. And it can lead to really long, potentially quite difficult negotiations between the founders and the investors.
Which burns time and money the startup can't afford to waste.
Precisely. They need to be building, not arguing over valuation for weeks. So the CLA lets everyone sort of hit pause on that debate. The investor puts the cash in now as a loan.
Okay.
And the price per share that loan eventually converts at. That's determined later. Usually when the companies achieve more back, maybe launched the product, got users, started generating revenue, that makes the valuation discussion hopefully more informed and less adversarial when the next round happens.
So it's a pragmatic fix for early-stage uncertainty.
It is, especially when getting cash in the door quickly is the top priority.
And that speed element is real. The sources suggest CLAs can often be done much faster and potentially with lower upfront legal costs compared to a full-priced equity round.
Yeah, the lighter documentation and skipping the valuation fight definitely speeds things up initially.
Okay.
But, and this is a really important point for you advising clients, you have to grasp the hybrid nature. We touched on it, but legally. It is debt. It usually has interest, a date it needs to be repaid by if it doesn't convert the maturity date.
Okay, so it has debt features.
Definitely. But commercially, especially from the VC investor's perspective, they often view it almost entirely as deferred equity or unpriced equity.
Meaning the investor isn't really banking on getting their loan back plus interest in cash?
Not as their main hope, no. Their fundamental expectation, their goal, is that the company will succeed, raise that next round, and their loan will convert into shares. They want to own a piece of the company to benefit from future growth and exit.
They're thinking like equity holders from the start.
Pretty much, yeah. They're using a debt structure for convenience and speed. But this dual character, it can cause problems if expectations aren't aligned. What happens if the company doesn't raise that next round by the maturity date?
Then the debt becomes legally repayable in cash.
Right. And if the startup hasn't got the cash, which is common, well, it creates a difficult situation.
That really highlights the need for super clear documents and making sure everyone understands all the possibilities, not just the rosy conversion scenario.
Absolutely critical. Clear communication, understanding the what-ifs. And this specific nature of the UK CLA, this hybrid character, its common usage, is exactly why you and Luxembourg need to understand it.
Because we'll encounter it in cross-border deals.
You will. Advising Lux funds investing into the UK or UK companies raising from Lux investors, you need to know how this instrument works, its pros and cons in the UK market context. It's fundamental for giving good advice.
Makes perfect sense. It's about practical application, not just theory. Now, you mentioned it's not the only game in town for early UK funding. The sources compare CLAs to things called Advanced Subscription Agreements, ASAs, and UK versions of Simple Agreements for Future Equity, SAFEs. We need to understand the differences.
Yeah, that's important context. They often get used for similar purposes, early funding, deferring valuation, but they are legally distinct. The sources lay out the key differences pretty clearly.
Okay, walk us through it. What's the most basic difference?
Their legal form. Right. So a UK CLA, as we've said, is legally debt, creates a debtor-creditor relationship. An ASA, an Advanced Subscription Agreement, is structured differently. It's essentially a prepayment for shares that will be issued later. The investor pays now for shares they'll receive down the line.
Okay, paying up front for future shares. And a SAFE.
A SAFE, a simple agreement for future equity, is more of a contractual right to receive equity in the future, often triggered by a funding round. It's sometimes seen as similar to a warrant. It's generally not considered debt, nor quite the same as a prepayment like an ASA.
So debt versus prepaid equity versus a contract for future equity.
Got it. What about interest? Do ASAs and SAFEs have interest like CLAs often do? Generally, no. UK CLAs typically do accrue interest, often that payment in kind, PIK interest we talked about, where it adds to the loan balance. ASAs and SAFEs usually don't accrue interest. That's a clear economic difference.
And what about getting repaid if things go south? Or the ranking in an insolvency? That seems like a big difference for the investor's risk.
Huge difference. Because the CLA is debt, there's a legal obligation for the company to repay the principal and interest if conversion doesn't happen by maturity. And crucially, if the company goes bust, CLA holders are creditors.
Meaning they get paid before shareholders.
Exactly. They rank ahead of shareholders in getting any money back, though they'd be behind secured creditors if there were any. ASAs and SAFEs, they don't create debt. So there's no inherent repayment obligation if conversion fails, and importantly, the holders are not creditors in an insolvency.
So they're treated more like shareholders if the company fails.
Essentially, yes. Their money is treated as an advance for equity. That difference in creditor status gives CLA holders a layer of downside protection that ASA and SAFE holders lack.
Okay, that's a critical distinction. Now, you hinted at something else that really drives the choice in the UK. Tax reliefs. SAIs and EAS.
Ah, yes. This is the big one, especially for UK-based angel investors. SEAS, the Seed Enterprise Investment Scheme, and EIS, the Enterprise Investment Scheme, offer very attractive UK tax benefits to individuals investing in qualifying early-stage UK companies. We're talking income tax relief, capital gains benefits, loss relief. It's significant.
And CLAs don't qualify for these.
Generally, no. The rules for CSSF require the investment to be made for new shares in the company from the outset, amongst other conditions. A loan, even one intended to convert later, doesn't meet that initial requirement.
But ASAs can qualify.
Yes, ASAs can be structured specifically to be compatible with CSSF. The key is usually that the agreement must ensure the shares are actually issued within a defined period, often using what's called a long stop date, commonly around 6 months. If the shares are issued by then, the investment can potentially qualify.
So if you're a UK angel wanting those tax breaks, you'd likely prefer an ASA over a CLA.
Very often, yes. This CSSF compatibility is a massive reason why ASAs are so popular for UK seed rounds funded by angels. UK-adapted safes also try to build in features, like long-stop dates, to make them CSSF compliant too.
So for you, our listener in Luxembourg, understanding the CSSF angle is vital. It explains why a UK company might be pushing for an ASA or a SAFE structure, even if a CLA seems fine otherwise. It's a huge driver in the UK market.
Absolutely. Well, all three CLA, ASA, SAFE defer the tricky valuation using discounts and or caps on a future round. Their legal nature, interest, insolvency ranking, and especially CSSF eligibility are very different and dictate when each is typically used in the UK.
Okay, that's excellent context on the instrument itself and its UK relatives. Now let's shift gears to the specific UK legal and regulatory framework that surrounds these CLAs. For advising on cross-border deals, knowing this is crucial to ensure everything is above board and enforceable.
Right. Two main areas here. First, the UK's financial services regulation. Does lending via a CLA need FCA authorization? And second, UK company law. Does the company actually have the power to issue the CLA and, more importantly, the shares later?
Let's tackle the regulatory side first. Is this type of lending usually regulated activity under UK law, needing FCA approval?
That's the first question you have to ask. The Financial Services and Markets Act 2000 FSMA and the Regulated Activities Order, or RAO, define what needs authorization if it's done by way of business. Getting this wrong is serious. Agreements could be unenforceable.
So how do typical VC deals using CLAs usually handle this? Do they need authorization?
Generally, no. They usually rely on specific exemptions within the RAO to stay outside the regulatory perimeter.
Okay, what's the key exemption?
The main one for standard VC CLAs is the business loan exemption in Article 60C2 of the RAO.
And what does that say?
Broadly, it exempts credit agreements from regulation if the loan amount is over £25,000, and the borrower, the company, enters into it wholly or mainly for the purposes of a business they carry on or intend to carry on.
So a VC fund lending, say, £500,000 to a UK startup for product development and growth, that seems to fit perfectly.
It usually does. VC investments via CLAs are almost always well over $25K, and the money is clearly for the company's business purposes, operations, R&D, hiring, etc.
Is there a sort of underlying principle behind that exemption?
Yes. The idea is that lending significant sums to corporate entities for business purposes involves sophisticated parties on both sides who can look after themselves, so the full consumer credit protection regime isn't deemed necessary.
Are there any other bits of regulation to quickly check?
You might briefly consider if the company accepting the funds falls under accepting deposits, usually excluded is structured as a debt security, or if the company issuing the CLA is dealing in investments, usually excluded. Separately, the fund manager or arranger also needs to ensure their own activities, like sourcing and negotiating the deal, fit within exemptions related to arranging deals if they aren't FCA authorized themselves.
Okay, so the key takeaway here for you, our listener in Luxembourg, on the regulatory front, When reviewing a UK CLA deal, make sure you or UK counsel confirms the lending activity clearly falls outside the UK regulatory perimeter using these exemptions. Don't just assume it's unregulated.
Absolutely. Verifying that is a standard non-negotiable legal DD point on the UK side.
Right. Now let's switch to the company's own internal power, its corporate authority. Why is this so critical for a UK company issuing a CLA?
Because the company needs the legal capacity, not just to take the loan, but crucially, to fulfill its main promise, issuing the shares when conversion happens. This is governed by the UK Companies Act 2006 and the company's own rulebook, its Articles of Association.
Do directors normally have the power to borrow money?
Generally, yes. Directors' management powers, often set out in the articles, like Model Article 3, usually cover borrowing and granting security, unless the articles specifically restrict this or require shareholder approval above certain limits.
Okay, so borrowing is usually fine. But issuing shares, that feels different. Can directors just decide to issue shares for the conversion?
No, absolutely not. That goes beyond their general management powers. Issuing shares or granting rights like a CLA that convert into shares requires specific authorization for the shareholders.
Okay, what specific shareholder approvals are needed then?
Two key ones under the Companies Act 2006. First, directors need authority to allot shares under Section 551. This permission is usually given by an ordinary resolution of shareholders, a simple majority vote, or it can be pre-baked into the articles.
And this permission has limits.
Yes, it must state the maximum number of shares the directors can allot, and it has an expiry date, typically no more than 5 years. Crucially, this authority needs to be large enough to cover the maximum potential number of shares needed for the CLA conversion, including any shares for PIK interest.
Okay, authority to allot. What was the second one? Something about preemption rights.
Exactly. Under Section 561 of the Companies Act, existing shareholders have a default right called preemption rights to be offered any new shares, and the company issues for cash first, in proportion to their existing holdings.
And converting a CLA counts as issuing shares for cash?
Generally, yes, it's treated that way for preemption purposes. So if you want to issue the conversion shares directly to the CLA holder without first offering them pro rata to all existing shareholders, you need to switch off or disapply these statutory preemption rights.
How do you do that?
It can be done in the articles, but more commonly for a specific fundraising or CLA issuance, it's done by a special resolution of the shareholders. That requires a higher majority, 75% of votes cast.
Okay, so let me recap the corporate approvals needed. Board approves the loan itself. Shareholders pass an ordinary resolution, 50% plus, to authorize the directors to allot enough shares for the maximum conversion amount. And shareholders pass a special resolution, 75% plus, to disapply preemption rights for that specific share issuance on conversion.
That's the trifecta you need. And the critical point is, if the company messes up and fails to get any of these authorizations properly documented, the investor's right to convert the loan into shares could be legally unenforceable.
Wow, so the investor might have put money in but can't actually get the shares they expected?
Potentially, yes. Their core right depends entirely on the company having the proper corporate power to issue those shares. That's why checking the company's articles and ensuring these resolutions are passed before the CLA is signed is so fundamental for the investor's protection.
This is a massive takeaway for you, our listener. Advising a Lux fund on a UK CLA. Make absolutely sure that UK counsel confirms the target company has nailed down all these board and shareholder approvals. It's not just paperwork. It underpins the entire investment thesis for your client.
Couldn't agree more. It's foundational due diligence.
Okay, let's pivot to another crucial area, tax. Always complex, always important. What are the key UK tax angles for a CLA, both for the UK company issuing it and the investor putting in the money?
Right. This involves specific UK tax rules, HMRC guidance. Let's start with the issuer, the UK company taking the loan. How is the conversion treated for them?
Does the company pay tax when the debt turns into equity?
Generally, no. For the UK company, the actual conversion event itself, extinguishing the debt by issuing shares, is usually treated as a tax nothing. They typically don't realize a taxable profit or loss just from that conversion. That's usually helpful for the company.
What about the interest paid or accrued on the loan before conversion?
Okay, so the underlying loan part of the CLA is a loan relationship for UK corporation tax. Generally, the interest expense the company accrues or pays on that loan is tax deductible as a loan relationship debit, reducing their taxable profits. But there are rules and potential restrictions.
And we mentioned PIK interest as common payment in kind. How does that work for the company's tax deduction if no cash is actually paid?
Good question. For UK tax, when PIK interest is capitalized added to the loan principal, it's generally treated as if it has been paid at that point. This means the company can usually claim the tax deduction for that interest in the period it's capitalized, even without a cash outflow. This can be helpful under certain rules that might otherwise defer deductions for unpaid interest.
Is that interest deduction always guaranteed, or are there limits?
There are definitely limits. The main one to be aware of is the corporate interest restriction, or CIR rules. These can limit the amount of net interest expense a company or group can deduct for corporation tax each year.
How does that work?
Broadly, the deduction is often capped at 30% of the company's UK taxable profit, adjusted, like a tax EBITDA figure, although there's a £2 million group de minimis threshold. Interest on CLAs, including that PIK interest, does count towards this limit.
So for a startup with maybe low profits or even losses?
Exactly. For an early-stage company with low or negative EBITDA, the CIR rules could significantly restrict their ability to get immediate tax relief for all the interest accruing on the CLA. That's a key risk factor for the company's financials.
Okay, so for the UK company, conversion is neutral, interest usually deductible, but CIR is a major watch-out. PIK helps with timing the deduction. Now, flip side. The lender, the investor, how's their interest income treated?
For the investor, it depends on who they are and where they are. If it's a UK corporate investor, the interest income, including any PIK interest as it accrues, is generally taxable as a loan relationship credit. If it's a UK individual, it's typically taxable as interest income.
That PIK interest sounds like it could create a cash flow issue for the investor paying tax on income they haven't received in cash.
It absolutely can. When PIK interest is capitalized, it's treated as taxable income received by the UK corporate lender at that time. This creates what's called a dry tax charge. The investor owes tax on income they haven't actually received in cash yet. Investors need to be aware of and plan for this.
What about withholding tax? Does the UK company need to withhold tax when paying or accruing interest, especially to a non-UK investor?
Okay, important point for cross-border deals. Generally, there's no UK withholding tax, WHT, on interest paid between two UK companies. However, a 20% WHT can apply to payments of yearly interest. Broadly, interest on loans expected to last more than a year when paid by a UK company to a non-UK resident lender, like a Luxembourg fund, or to a UK individual.
So a potential 20% haircut on the interest?
Yes, unless that withholding tax is reduced or eliminated by a relevant double taxation treaty, like the UK-Luxembourg Treaty. Claiming treaty relief usually involves specific procedures. The question of whether WHT applies to peak interest has been discussed, but the potential liability remains something non-UK lenders must assess carefully.
So for you, our Luxembourg listener, advising a fund investing via a UK CLA, checking the UK WHT position on interest under the treaty is absolutely essential.
Non-negotiable. Finally, what happens for the investor when the CLA actually converts into shares? Is that a taxable event? Yes, generally it is. For the investor, the conversion is typically treated as a disposal of their debt instrument, the CLA, in exchange for the shares. This is usually a taxable event for UK capital gains tax purposes or corporation tax on chargeable gains for companies.
How is the gain calculated?
Typically, it's the market value of the shares received at the time of conversion minus the investor's base cost in the debt. That base cost would be the original principal amount loaned, plus any PIK interest that has already been taxed as income along the way. Various reliefs might apply depending on the investor.
So interesting asymmetry. Conversion is tax neutral for the company, but a taxable event for the investor.
That's correct. It's a standard feature of how these instruments often work from a tax perspective. The big takeaway for you in Luxembourg. UK tax on these instruments is complex. Get specialist UK tax advice. You need to understand the implications for the UK company and for your Luxembourg-based client, the interest treatment, the WHT risk, the tax on conversion. Don't make assumptions.
Sound advice. Tax always needs experts. Okay, let's move to the practicalities, the actual documents needed to put a UK CLA in place. It's not just signing one agreement, right?
No, definitely not. You need a package of documents to make sure everything is legally buttoned up and the rights are clear and enforceable.
What's the main document, the core agreement?
That's the convertible loan agreement instrument itself. This is the contract signed by the company and each lender. It lays out all the key commercial and legal terms we've been discussing.
Principal, interest, maturity.
Exactly. Principal amount, interest rate, how interest accrues, especially PIK, the maturity date, what constitutes an event of default, the repayment terms, and crucially, the detailed conversion mechanics, the triggers, the discount, the valuation cap. plus things like undertakings and warranties. This is where the deal is defined.
Needs careful drafting and negotiation, clearly. What else is essential besides the main agreement?
You absolutely must have the UK corporate resolutions. These are the internal company documents proving the company has the authority to do the deal and, critically, to issue the shares upon conversion later.
We talked about how vital those authorities are. What do these resolutions look like in practice?
You'll have board minutes or a written resolution signed by all directors showing the board approved entering into the CLA, the borrowing terms, authorized specific people to sign it, and approved any security being granted if applicable.
Okay, board approval and shareholder.
Yes, you need the shareholder resolutions we discussed earlier, documented either in minutes of a shareholder meeting or via written resolutions signed by the required majority of shareholders. That's the ordinary resolution for the Section 551 authority to allot shares.
Making sure there's enough headroom for conversion shares plus PIK.
Right. And the special resolution for the Section 561 disapplication of preemption rights.
And without these resolutions properly documented.
The enforceability of the investor's core conversion right is at risk. These are not mere formalities. They're essential legal underpinnings.
Got it. What about security documents? Are CLAs usually secured in the UK?
That's a key point. Many, perhaps most, early-stage UK VC CLAs are unsecured. That's quite standard market practice.
But if security is agreed?
Then yes, you need additional security documentation. Typically in the UK, this would be a debenture.
A debenture? What does that involve?
A debenture is the UK legal document used to create security over a company's assets. It acknowledges the debt, the CLA, and creates charges over the company's property.
What kind of charges?
Usually a mix. Fixed charges over specific key assets, like maybe the company's main intellectual property or real estate if they own any. The company can't sell or deal with fixed charge assets without the lender's consent, and usually a floating charge over classes of assets that change over time, things like stock, raw materials, cash receivables. The company can deal with these freely until something goes wrong, like an event of default, at which point the floating charge crystallizes and attaches to the assets present at that time.
And you mentioned a critical step needed to make this security effective against others.
Yes, absolutely vital. Perfection. For the security created by a UK company's debenture to be valid against a liquidator or other creditors, if the company gets into trouble, the charge must be registered at the UK's Companies House.
And there's a strict deadline for that.
Extremely strict. You have 21 days, starting the day after the charge is created, to get a certified copy of the debenture in the required Form MR01, filed at Companies House.
Just 21 days. What happens if you miss that deadline?
The consequences are harsh. The security becomes void against a liquidator, administrator, or any other creditor. The debt under the CLA still exists and usually becomes immediately repayable, but it ranks as unsecured debt. The lender loses their priority position.
So for you, our listener, if you're involved in a UK CLA deal where the investor has negotiated security, that 21-day company's house registration deadline is non-negotiable and absolutely critical to track. Missing it effectively destroys the value of the security.
Precisely. It's a procedural step with massive substantive consequences.
Okay, we've got the core documents covered. Now let's dive deeper into the specific terms and clauses within that main convertible loan agreement document. What are the really important ones we need to understand thinking about the UK market and how a Luxembourg professional should view them?
Right. Let's go through the key clauses, thinking about their legal purpose, the commercial point, how they're usually drafted in the UK, and any specific nuances to flag.
Great. Let's start simple. The principal amount.
Okay. The principal amount is just the total sum of money being loaned. Legally, it defines the initial debt. Commercially, it's the cash injection for the company and the starting point for calculating interest and conversion shares. UK agreements are usually very clear, often using a schedule if there are multiple lenders.
Next up, interest. This is where that PIK concept is really dominant in UK VC, isn't it?
Hugely dominant. So interest is the lender's compensation for risk and providing capital. While some loans pay cash interest, UK VC CLAs almost always use payment in kind, PIK interest.
Remind us how PIK works again.
Instead of paying cash interest periodically, the accrued interest is simply added to the outstanding principal loan amount. So the debt grows over time. This bigger amount then accrues more interest, and ultimately it's this larger total amount, original principal plus all the capitalized PIK interest, that converts into shares.
Which is good for the company's cash flow.
Very good. Yeah. Preserves cash. UK TLAs will clearly state the annual interest rate, maybe 4%, 8%, 10%, specify its PIK, and how often it compounds or capitalizes. For example, quarterly, annually.
What's the crucial takeaway on PIK for someone advising a Luxembourg investor?
Beyond the UK tax point, we discuss the potential dry tax charge. The key commercial point is that PIK significantly increases the amount converting into equity. This means more dilution for existing shareholders and a larger equity stake for the CLA holder than just the principal alone would suggest. You have to model that compounding effect when assessing the deal.
Right, it bumps up the converting value. What about the maturity date?
The maturity date sets the deadline. It's the final date by which the loan must either have converted into equity or be repaid in cash. Its purpose is to give the deal a finite term, put some pressure on the company to hit a conversion milestone, and give the lender an end date.
What's a typical maturity period in the UK?
Common to see 18 months, 24 months, maybe up to 36 months. Some sources mention even longer, but 1.5 to 3 years feels pretty standard for UK VC CLAs. If no conversion happens by this date, legally, the debt becomes due for repayment.
What if conversion doesn't happen by maturity? Is repayment the only option?
Not always. Sometimes the CLA might specify that if maturity is reached without a prior qualified financing round, the loan automatically converts into shares at a pre-agreed minimum valuation, often called a floor valuation. Or, more commonly, it might give the lender the option at maturity, either demand cash repayment or choose to convert at that floor valuation. This leads us to repayment events more generally.
Tell us about those. When else might the loan need to be repaid in cash?
Repayment events define the circumstances triggering a cash repayment obligation, principal, interest, maybe a premium. It's the lender's path to getting cash back if conversion fails or isn't the best option. Key triggers are: 1. Repayment at maturity, if no earlier conversion. 2. Repayment upon an event of default, where the lender can accelerate the debt. 2. Repayment upon an event of default. 3. Sometimes repayment upon an exit or sale of the company. The lender might have the option to take cash instead of converting, especially if the cash repayment gives them a better return.
You mentioned a premium on repayment.
Yes, sometimes a redemption premium is included. This is an extra amount payable on top of the principal and interest, often calculated as a percentage of the principal. For G, the Future Fund CLA had a 100% premium in certain exit scenarios. It's a way to boost the lender's return if conversion doesn't happen or isn't favorable, especially on an early exit. It's a notable feature you sometimes see in UK CLAs.
Okay, now for the absolute core, the conversion mechanics. How does the debt actually turn into shares?
This is the heart of the CLA for investors. It defines how they get their equity upside. 2 key parts: the conversion triggers, what makes it convert, and the conversion price mechanics, how the price per share is set.
What are the usual triggers that cause conversion?
The most common by far is a qualified financing round, QFR. That's the next significant equity investment round from new investors, meeting a minimum size threshold defined in the CLA. Example, raising at least £1 million. Defining that QFR threshold is a key negotiation point. Another standard trigger is a sale or liquidity event, like the company being sold, merging, or having an IPO. Conversion usually happens automatically just before such an event closes. Then there's conversion triggered by the maturity date, as we discussed, either automatic at a floor price or lender option. Sometimes lenders might also get an option to convert if the company does a smaller funding round, a non-qualified financing round. And less commonly, a lender might just have an option to convert at their discretion, maybe after a certain time or milestone. Okay, those are the triggers. Now, how is the price per share calculated when conversion happens? This is where the discount and cap come in. Exactly. The whole point is for the early CLA investor to get shares cheaper than the new investors coming into that QFR. This reward for early risk is achieved using 2 main tools. 1, a discount rate, a percentage discount applied to the price per share paid by the QFR investors. Common discounts in the UK are around 10–25%, with 20% being quite standard. 2, a valuation cap. This sets a maximum pre-money valuation of the company for the purpose of calculating the CLA holder's conversion price. For example, a $5 million cap means even if the QFR happens at a $10 million valuation, the CLA converts as if the valuation was only £5 million, resulting in a lower price per share.
So the cap protects the early investor if the company's valuation shoots up quickly before the QFR.
Precisely. It prevents their early investment being overly diluted by a very high valuation in the next round. The specific cap level is highly negotiated and deal-specific.
And I think you mentioned the UK market typically uses both the discount and the cap together.
Yes, very standard UK practice is the lower of calculation. The actual price per share the CLA converts at is the lower of these 2 calculations. Price per share in the QFR minus the discount rate, or the price per share implied by the valuation cap.
So the investor gets whichever calculation gives them the better, lower price.
Exactly. It gives them downside protection via the discount and upside protection via the cap.
What kind of shares does the CLA convert into ordinary shares, preference shares?
Typically, it converts into the same class of shares being issued to the new investors in the qualified financing round. So if the QFR investors get Series A preference shares, the CLA converts into Series A preference shares too. If conversion happens on an exit or at maturity, it might convert into the most senior class of shares then outstanding. The company also usually has to give the lenders formal notice before conversion occurs.
Okay, that lower of cap and discount mechanism, plus remembering that the entire amount, including key IAC interest, converts, feels like the absolute core calculation for a Luxembourg professional to grasp when modeling potential outcomes.
Absolutely. That's where the economics are defined. Now, what happens if things go wrong before conversion? Let's talk about events of default, EODs.
Right. What are these?
Events of default are specific bad things happening that breach the agreement and give the lender special rights, usually the right to demand their money back immediately. They protect the lender if the company gets into trouble or breaks its promises.
What are typical EODs in a UK VC CLA?
Common ones include failure to pay principal or interest when due, less relevant for PIK but critical on maturity, a material breach of the company's promises, undertakings covenants, making false statements, misrepresentation. Crucially, insolvency events, the company going into administration, liquidation, receivership, etc. These are usually hard defaults with no cure period, sometimes defaulting on other significant debt, cross-default, a change of control of the company, though this is often also a conversion trigger, less commonly in VC, a material adverse change clause.
And if an EOD happens, what can the lender do?
The main remedy is acceleration. The lender can declare the entire outstanding loan amount, principal, accrued PIK interest, any premium immediately due and payable in cash.
Forcing a cash repayment.
Yes, and if the loan was secured, triggering an EOD allows the lender to start the process of enforcing their security, appointing a receiver or administrator to sell the charged assets to recover the debt. Some CLAs might theoretically allow conversion on default, maybe at a penalty rate, but acceleration is the standard remedy.
Are there usually grace periods before a default is triggered?
Yes, for certain types of breaches like failing to provide information, there's often a cure period or grace period, maybe 7, 14, or 30 days, where the committee gets a chance to fix the breach before it officially becomes an EOD. This usually doesn't apply to non-payment or insolvency, though.
How do UK VC EODs compare to, say, bank loans?
They're often described as being a bit lighter touch.
Yeah.
They acknowledge that startups are volatile. Negotiations often focus on defining what counts as material and the length of those cure periods.
Okay, next clause area, security.
Right. As we've said, this clause states whether the loan is secured and usually just references the separate debenture document if it is. Its purpose is to give the lender priority over other creditors in an insolvency, using the company's assets as collateral.
But the key UK nuance.
The key nuance is that early-stage UK VC CLAs are very often unsecured. That's the market norm. If security is given, then the UK specifics are the debenture structure, fixed floating charges, and that absolutely critical 21-day company's house registration requirement for perfection. For a Luxembourg audience, if security is in the deal, understanding that registration rule is paramount.
Got it. What about undertakings or covenants? What are these?
These are promises the company makes to the lenders about how it will operate during the life of the loan, before conversion or repayment. They aim to protect the lender's investment by ensuring the company maintains its value, provides information, and doesn't do things that could harm the lender's position.
What kind of promises are typical in a UK CLA? Are they very strict?
Again, often lighter touch than bank covenants, but core protections are usually included. Things like information rights. The company must provide financial reports, updates really important for unsecured lenders. A promise on use of proceeds. The loan money must be used for the business, not for paying dividends or lending to directors.
Yeah.
A negative pledge is very standard. The company promises not to create any new security that ranks ahead of or equal to the CLA without the lender's consent, though usually with some permitted exceptions for flexibility. Restrictions on taking on significant further debt. Restrictions on paying dividends or making other distributions to shareholders. Restrictions on selling off major assets. Plus general promises to keep proper books, comply with laws, maintain insurance, etc.
What gets negotiated here usually?
The scope and strictness. Lenders want strong controls and information flow. Companies want maximum operational freedom. The negative pledge details and exceptions are often discussed carefully.
Okay. Warranties and representations.
These are statements of fact the company makes about itself at the time the CLA is signed. Things like, we're properly incorporated. We have the power to sign this. Our accounts are accurate. This is our cap table. We own our key IP. There's no major lawsuit pending.
Why are these included?
The lender relies on these statements being true when deciding to invest. If a warranty turns out to be false, it's a breach of contract and could trigger an event of default, allowing the lender to potentially demand their money back. In UK VC CLAs, warranties might be less extensive than in a full equity round, but they cover the fundamentals. Sometimes founders might give warranties personally, which needs careful consideration regarding their liability, possibly mitigated by disclosures.
Transferability of the loan. Can the lender sell the CLA to someone else?
This clause covers that. It balances the lender's desire for potential liquidity, ability to sell their position, against the company's interest in knowing who its lenders and potential future shareholders are.
What are the options?
It can range from being freely transferable to transferable only with the company's consent, which might need to be given reasonably, to being restricted only to affiliates or existing investors, or sometimes aligned with restrictions on transferring shares. It's a negotiated point.
And finally, governing law and jurisdiction.
Standard clause specifies which country's laws interpret the agreement and which country's courts resolve disputes. For a UK company issuing a CLA, this will almost invariably be the law of England and Wales and the exclusive jurisdiction of the English courts.
Provides certainty.
Exactly. Provides legal certainty for everyone involved. For a Luxembourg investor, it just means being aware that the contract is English law, even if enforcement might eventually need to happen elsewhere.
That's a fantastic detailed walkthrough of the key clauses. It really paints a picture of the UK CLA structure. Now, with all these clauses and potential variations, where do the main arguments or negotiation points typically arise between the company and the investors?
Yeah, the negotiation really focuses on the balance between the company wanting capital with flexibility and the investor wanting a good return with downside protection. The main battlegrounds tend to be the economic terms and the key protective clauses.
So on the economics, what gets debated most?
The valuation cap and the discount rate. These directly impact the investor's ultimate equity stake and return. The company wants a higher cap and lower discount to minimize dilution. The investor wants the opposite, a lower cap and higher discount for a better entry price. These numbers are almost always heavily negotiated.
What else on the money side?
The interest rate, although PIK is standard, the actual percentage matters. And the maturity period, the company often wants longer to give them more time to hit milestones, while the investor might prefer shorter for quicker certainty or repayment.
And on the protection side, what are the friction points there?
The scope of the events of default and the undertaking's covenants. Investors want broad triggers and tight promises, like a strong negative pledge, good information rights. Companies push back, wanting more operational freedom and narrower default triggers with longer cure periods. And a big one, if it comes up, is whether security will be granted at all, since unsecured is the norm. Investor rights like board observer seats are also often negotiated.
What do the compromises usually look like in the UK market?
Well, on the cap and discount, it's very common now to have both included, with the investor getting that lower of benefit. A 20% discount is pretty standard, but the cap level varies enormously depending on the company's stage and traction. For interest, a moderate PIK rate, say 5% to 8%, is a frequent compromise. Balances investor return with company cash preservation. Maturity dates often land between 18 and 30 months. Enough time, but not indefinite. Covenants and EODs usually end up lighter touch than bank debt, focusing on genuinely material issues, with reasonable cure periods for fixable breaches. Observer rights are a common compromise instead of a full board seat pre-conversion. And for security, the common compromise is no security. Unsecured remains the typical outcome for early-stage UK VC CLAs. Getting security is a major win for an investor if they achieve it.
So the final terms really depend on the bargaining power of each side.
Absolutely. A hot company with lots of investor interest will get very founder-friendly terms. In a tougher funding environment, investors can demand more protection. But the core negotiation always revolves around that tension. Economic upside, cap discount interest, versus downside protection, maturity EAD security covenants.
Okay, let's talk about the other costs involved, beyond the actual investment amount. The sources say CLAs are generally quicker and cheaper than full equity rounds.
That's definitely one of their main selling points, yes. primarily because you skip the big valuation negotiation, and the documentation is usually less complex than drafting full new articles and shareholders' agreements.
So what are the typical costs? Legal fees must be the main one.
They are. It's hard to give exact UK figures as they vary so much. But even for a relatively straightforward CLA using standardish terms, you're looking at several £1,000s in legal fees for each side. If the negotiation gets heavy or the terms are very bespoke or there are lots of investors, those costs can climb significantly.
Depends on the lawyers, the complexity.
Exactly. Firm rates, experience, how much back and forth there is.
And if security is involved, that adds extra cost.
Yes. The actual company's house filing fee is small, maybe £15 or £25. But the significant cost is the extra legal time needed to draft, negotiate, and finalize the debenture document itself, and then manage that critical 21-day registration process properly. That adds materially to the legal bill.
Who usually pays these legal fees in a UK CLA deal?
It's a commercial point to agree, but there's a common pattern. The company issuing the CLA almost always pays its own legal costs for drafting the documents, managing its approvals, etc.
Okay.
The investors typically each pay their own legal fees for the review and negotiation. However, if there's a lead institutional investor managing the process, it's sometimes agreed that the company will reimburse a portion of that lead investor's legal fees, usually subject to a pre-agreed cap, maybe up to 5K or 10 PAV, for example.
Not always.
No, less common in very early angel rounds where often it's just agreed everyone covers their own costs. It's something that should be clarified up front, ideally in the term sheet, so everyone knows where they stand on costs.
So the takeaway is, while CLAs might be cheaper overall than a priced round, legal fees are still a real cost for both the company and the investors that needs to be factored in.
Definitely. It's a transaction cost you need to budget for.
Right. Now, back to that speed advantage. One of the big appeals of CLAs is getting deals done quickly. What's a realistic timeline? How fast can these actually happen?
Speed is definitely a key motivation. Once you have a signed term sheet outlining the main points.
Which is the agreement in principle.
Exactly. From that point, the process of drafting the final CLA document, doing the focused legal due diligence, getting the company's corporate approval sorted, and getting everything signed can be pretty swift.
So are we talking days, weeks, months?
Sources often mention days or weeks. In practice, assuming everyone is motivated and reasonably organized, and there are no major roadblocks, completing everything in 2 to 6 weeks from signing the term sheet to the money being wired is often achievable.
That sounds significantly faster than a traditional equity round.
Oh, much faster. A priced equity round with a valuation debate, full due diligence, negotiating detailed shareholders agreements, and new articles that routinely takes 2 to 4 months, sometimes longer.
How does the CLA speed compare to those other instruments, ASAs and SAFEs?
They can be similarly fast, potentially even quicker than CLAs if very standard forms are used with minimal changes. They also benefit from deferring the valuation discussion. So CLA, ASA, SAFE, generally much quicker options than a priced round.
What are the things that can slow down a CLA deal and push it towards the 6-week end of the range, or even longer?
Several factors. Heavy negotiation on the key terms, caps, discount, interest, covenants that obviously adds time. The sheer number of investors involved coordinating comments and signatures from many parties takes longer. While due diligence is lighter, if unexpected issues crop up or investors demand deeper dives, that adds delay. The company's own readiness is huge if their records are messy, getting shareholder approvals is difficult, or they're slow providing information, things grind to a halt. Including security adds a definite extra phase for the debenture and that critical 21-day registration. And honestly, just the responsiveness of everyone, the management, the investors, the lawyers on both sides is crucial. A detailed term sheet helps speed up the final docs. A vague one means you're still arguing key points later.
So speed is an advantage, but it relies on efficiency and clear agreement up front.
Exactly. It doesn't happen automatically.
Yeah. Okay, we have covered a huge amount on UK CLAs, the what, why, who, when, the legal framework, tax, documents, clauses, negotiation costs, timeline. Now let's bring it right back home. Specifically for you, our listener working here in Luxembourg, how do these UK CLAs compare to instruments you might be more familiar with under Luxembourg law or market practice?
Yeah, this is a crucial comparison. But first, a really important caveat. You won't find a perfect, direct equivalent of a UK VC-style CLA in Luxembourg with identical features and treatment. The legal systems, regulations, tax rules, and market conventions are different.
Right, we can't just assume convertible loan means the same thing everywhere. But can we look at structures in Luxembourg that aim for a similar economic result debt, now, equity later?
Yes, we can definitely do that. One common approach you might see in Luxembourg is combining a straightforward loan agreement, a PRED, with the issuance of share warrants, bons de souscription d'actions or BSAs.
Okay, a loan plus warrants. How does that compare functionally to a UK CLA?
Well, it achieves a similar goal. The loan provides the initial capital, like the CLA principal. The warrants give the investor the right to subscribe for shares later at a pre-agreed price or formula, providing the equity upside, similar to the CLA's conversion right.
What's the main operational difference?
It's twofold. First, it's legally two separate instruments governed by their own terms. Second, and perhaps more importantly, when you exercise a warrant under a Luxembourg BSA, you typically have to pay new money to the company to buy the shares at the exercise price.
Whereas the UK CLA converts the existing debt.
Exactly. The UK CLA turns the money already invested, principal plus PAK, into shares. No new cash needed from the investor at conversion. That cash flow difference at the point of getting equity is fundamental.
What about formal convertible bonds, obligations convertibles under Luxembourg law? They sound closer in name.
They are conceptually closer. Yes, debt that converts into equity. Luxembourg law definitely provides for these.
How might they differ from the typical UK VC CLA in practice?
The Luxembourg framework for formal convertible bonds, even if issued privately, can sometimes involve more prescriptive corporate law hoops to jump through, compared to the flexible contract-driven UK VC CLA.
More formal requirements.
Potentially. Depending on the structure, there might be more detailed rules around board and shareholder approvals, maybe needing reports from auditors on the conversion value or the impact on capital. UK VC CLAs often feel a bit more agile and less constrained by specific corporate procedures beyond the general share allotment rules we discussed. Also, the typical UK CLA's unpriced nature, relying on a future QFR with a cap discount, might be less common in Lux convertible bonds, which might use fixed conversion ratios or formulae less directly tied to a future market valuation event.
Okay. And what about just simple loans from existing shareholders?
You certainly see shareholder advances or loans in Luxembourg companies, sometimes with an understanding or agreement that they'll be converted into equity later, perhaps during the next funding round. That shares the basic debt-to-equity idea.
But are they typically as formal or investor protective as a third-party CLA?
Often, no. These internal advances can be much less formalized. They might lack the standard investor protections found in UK CLAs, like a specific valuation cap or discount negotiated up front. The conversion terms might be looser or left more open to future agreement.
So if we try to summarize the key distinctions between UK CLAs and these potential Luxembourg parallels, what stands out?
Okay, drawing on the sources and our discussion. Formality docs. UK VC CLAs often aim for simplicity, standardization, contract focus. Lux instruments like formal CBs might carry more procedural weight, potentially involving notaries or more detailed corporate steps. Security. UK CLAs typically unsecured, if secured. UK debenture plus critical 21-day registration. Luxembourg has its own distinct security types, pledges, mortgages, with Lux-specific perfection rules and registries. Completely different system. Key terms. The UK market has strong conventions around the valuation cap plus discount plus lower of calculation and standard PIK interest. While Lux instruments can offer discounts or fixed prices, that specific UK cap mechanism linked to a future round isn't as embedded or might be structured differently. Regulation. UK CLAs often rely on specific FSMA exemptions, like the business loan one. Luxembourg Financial Regulation, CSSF oversight, operates under entirely different rules regarding lending, securities issuance, licensing triggers by way of business tests, and available exemptions. You need a separate Lux regulatory analysis. UK has its specific system CIR limits on interest deduction, PI treatment, potential WHT for non-residents, treaty dependent, taxable conversion for the investor. Luxembourg has different rules for interest deductibility, for example, thin cap. Generally limited WHT on arm's length interest, different conversion treatment, plus its own array of holding company or financing regimes that might benefit Lux investors. Entirely separate tax analysis needed. Sizes. This is a huge UK-specific factor driving instrument choice favoring ASFIs for angels. Luxembourg doesn't have a direct equivalent general investment scheme like this.
That comparison really drives home the point. Even if the goal looks similar, funding now, equity later, the legal wrapper, the market norms, the regulatory checks, the tax consequences, they are distinctly different between the UK and Luxembourg.
Absolutely. You absolutely cannot assume a term or concept translates directly or has the same implications. Convertible loan means different things in different contexts.
Which circles us back to the essential advice for you, our listener in Luxembourg. If you're advising on any cross-border deal involving a UK CLA, whether your client is the Lux Fund investing or the UK company receiving Lux investment, you must ensure specific, expert legal and tax advice is obtained in both jurisdictions.
Non-negotiable. How do you enforce English law rights in Luxembourg? What happens to UK security if the company has Lux assets or enters Lux insolvency? Which country gets to tax what under the treaty? These all require dual jurisdiction expertise.
Well, this has been a truly comprehensive deep dive. We've really unpacked the UK convertible loan agreement, guided by all the source material you shared with us. We've looked at what it is, why it's used, its place in the UK market, the critical UK legal and tax framework, the documentation, the key terms, negotiation points, costs, and timelines, and crucially, put it all in context for your work here in Luxembourg.
It's a key instrument to understand for anyone involved in that UK Lux VC corridor. Hopefully this has been helpful.
I'm sure it has. As we wrap up, here's a final thought for you to mull over, building on that comparison we just made. Given the UK CLA's quite specific mix, its debt form but equity goal, its reliance on particular UK regulatory carve-outs, its unique tax and corporate law interactions, how might the growing flows of venture capital between places like the UK and Luxembourg influence the future? Will we see more standardization of these early-stage tools globally? Or will national differences like the ones we've discussed continue to shape distinct, perhaps even diverging approaches to funding innovation? Something to think about. Thank you so much for joining us for this deep dive into UK convertible loan agreements. We really hope this detailed analysis, based on the sources you provided, has given you valuable practical insights for your work in Luxembourg's legal and financial sectors. We definitely encourage you to keep exploring the topic and, as always, consult with qualified specialists for advice tailored to your specific situation. Hit that like and subscribe button.
Thanks for listening.
It was the Luxembourg Fundcast for you today. This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice.